Welcome back to the channel. I'm Anthony Brown. I'm still your very own cyber lawyer and digital advocate. We're analyzing a few United States federal and state laws as well as judicial decisions. We're kicking off with the DMCA, the Digital Millennium Copyright Act. It's a law that protects creative work online. If someone copies your music, video, artwork, or writing without permission, they can sue and get paid for the damage. You can either claim the actual money you lost or ask for statutory damages, which means the court picks a certain amount, usually between $250 and $10,000 for each work that was stolen. And if someone copied multiple pieces or if more than one infringer is involved, the courts can multiply the damages. The more works infringed, the more compensation you could receive. Now, while copyright infringement isn't a cyber tort in the strict sense, it's about emotional harm and reputation. It often goes alongside other online wrongs. For example, if someone steals your content and also spreads lies about you or uses your work to scam others, it becomes part of a bigger pattern of online abuse. Think of the DMCA as one tool in the legal toolbox for fighting back when your creative rights are violated online. We have the Computer Fraud and Abuse Act. It's a US law that protects computer systems from unauthorized access and damage. It doesn't just apply to hackers, it also allows private individuals and companies to sue if someone messes with their systems in a way that causes harm. One case that tested the limits of this law was Intel Corporation against Hamidi. Karush Hamidi, a former Intel employee, sent 6 mass emails over 2 years to thousands of Intel workers. His emails criticized Intel's workplace practices, but they didn't hack into the system because they didn't cause any technical damage or slow anything down. Intel argued that Hamidi's email were a form of trespass to chattels. Chattels is a legal term that usually applies when someone interferes with your personal property. But the California Supreme Court disagreed. They said if the emails didn't harm the computers or affect how they worked, it's not trespass. The court made three key points. Intel's computers weren't physically damaged. The disruption was emotional or social, not technical. To claim trespass, there must be real interference with how the property works or its value. Still, the court left the door open. They said that bulk email spamming could be trespass if it actually slows down or damages a system. That's what happened in an earlier case, CompuServe against Cyber Promotions, where massive spam clogged up servers and justified a trespass claim. The bottom line is sending emails isn't illegal just because they are annoying or critical, but if they overload or harm a system, that's a different story and it could land your ass in court. Thirdly, in Minnesota, the law takes revenge pornography serious. If someone shares a private sexual image of you without your permission, even if you originally agreed to take or privately share it, you have the right to sue. Under the 2022 Minnesota Statute 604-30-31, you can take legal action if the image was created in a private setting, you're clearly identifiable, and you didn't agree to it being made public. And the law doesn't just stop at saying, don't do it. It gives victims real tools to fight back. You can claim money for emotional pain and financial loss, any profits the offender made from sharing the image, a civil penalty of up to $10,000, and coverage for your legal fees and court costs. Plus, the court can issue restraining orders or injunctions to stop further harm. If someone breaks those orders, they can be fined up to $1,000 per day of violation. Minnesota courts can hear the case if either person lives in the state or if the image was stored or shared there. This shows that there's a growing understanding that digital privacy matters and that victims deserve justice. even if no criminal charges are filed. We have the Communication Decency Act, Section 230. It's often called the legal backbone of the internet. It's the reason platforms like Facebook, YouTube, and Reddit aren't held responsible for what users post, even if those posts are false, offensive, or harmful. The law says that online platforms are not the publishers of user content. They can't be sued for things like defamation or misinformation posted by others. This protection is found in Section 230, paragraph C sub 1, which basically says if someone else wrote it, the platform isn't legally responsible for it, but there are limits. Section 230 doesn't protect platforms when federal criminal laws are broken, like trafficking or child exploitation, and when intellectual property rights are violated, like copyright infringements, amongst other exceptions provided in the Acts. One case that shows how this works is Packer against Google Incorporated. Gordon Packer, a writer, claimed that Google defamed him by indexing and storing old online posts. But the court ruled that Google was just a search engine. It didn't write or edit the content, it simply organized it. Since Google didn't actively create or endorse the material, it was protected under Section 230. The court said Google's role was mechanical and passive, not intentional or editorial. Even if the content was harmful, Google couldn't be held liable. You can imagine this kind of ruling has sparked debate. Critics say Section 230 lets platforms off the hook too easily, even when harmful content spreads widely. Victims of online abuse or misinformation often feel there's no one to hold accountable if you're not going to hold the internet service providers responsible. In the more recent case of Gonzalez against Google LLC 2021, the court again sided with Google. It ruled that Google wasn't responsible for terrorist content posted by third parties, reinforcing the idea that platforms are protected unless they actively help create or shape the content. While Section 230 keeps the internet open and free flowing, it also raises tough questions about accountability and justice in the digital age. Finally, we have the common law torts of outrage, also known as intentional infliction of emotional distress, IIED. It's about holding someone accountable when their behavior is so extreme and reckless that it causes serious emotional harm, even if there's no personal injury. In the United States case of Hubbard against United Press International, the Minnesota Supreme Court officially recognized IIED as a valid legal claim, but they didn't award damages to the plaintiff in the particular case. And here's why. The court said the company's actions, though unpleasant, weren't outrageous enough to cross the legal line. The emotional distress claimed, like depression and embarrassment, weren't backed up by medical evidence. And the courts reminded everyone that IIED claims need strong proofs. Now, why does it matter in Nigeria? Nigeria follows common law. Courts often look to the United Kingdom for cases for guidance. So the IIED is especially relevant in cyber-related cases like cyberbullying or cyber stalking, where someone is repeatedly targeted online. Victims who suffer emotional trauma without physical harm and online behavior that's so cruel or humiliating it crosses into outrageous. When combined with Nigeria's Cybercrime Act 2015, which criminalizes online harassment, IIED gives victims another path, a civil remedy. That means they can sue for damages, not just to rely on criminal prosecution. If someone is harassed online and suffers deep emotional pain, Nigerian courts can use this thought to ask, was the conduct outrageous? Was the distress severe? And if the answer is yes, the victim may have a strong case. In my next video, I'll be discussing on the European Union, especially the GDPR. Thanks for watching. Follow for more on Cyber Torts. Stay safe. You can definitely imagine this kind of ruling has sparked debates. Critics say Section 230 lets